Good morning, everyone. Thanks for joining us. I think a lot of you, most of you are probably familiar with our organization. We are a sexual violence law center. So I'm gonna just kind of keep it brief. We are a nonprofit holistic law firm that exclusively serves survivors of sexual assault and sexual violence. We do so in a number of areas, which you can see there on the slide. We do this because it's been shown that when you have experienced domestic violence or sexual assault, your need for, your legal issues and need for assistance with those multiplies. We serve people of all ages, children, adults, people of all genders, and we are a statewide organization.
And very briefly, my name is Parte. I'm the director of the program, and you're listening to my colleague, Sarah Mooney, who is our pro bono counsel.
Yeah, thank you, Reedy. We're just jumping in because there's so much. Okay, so for our agenda today, we're covering several things. You can see there are a lot of things that we are not covering today, again, just in the interest of time, but there will be additional trainings to cover those topics. We're going to start with legislative intent behind the new protection order statute, and Reedy's going to talk about that.
Thanks, Sarah. So like Sarah said, we're covering a lot, so we're going to keep it pretty basic right now. We're also available for follow-up questions, and if you need technical assistance on cases that you're handling through the new legislation that's going to fully be in effect starting July, feel free to reach out to us. But it's helpful to know a little bit of the history and the background behind why this big overhaul of the protection order process. And so just so you know, most of you, I recognize names. There are so many advocates here and so many civil legal aid attorneys here. You all know that Washington has had 6 different protection order statutes that have been developed over time at different periods. And with the oldest being the domestic violence protection order, I think most of us are more familiar with the DVPOs, the sexual assault protection orders, and the anti-harassment orders. More recent are the stalking protection order and the extreme risk protection order. And each of these statutes had a lot of similarities, but also a lot of differences. And so the intention of the HB 1320, which was the 2021 session, and HB 1901 was to really figure out a way to update the 6 different statutes to ensure that firearms surrenders reduce harm, to really incorporate technology, things that we have been wanting on the advocacy side for a long time, which is electronic service, online filing, allowing for remote hearings. And for many of you, I know we've had conversations about, wouldn't it be great to be able to have a single petition instead of having survivors try to identify out of the 6 petitions, which one should they be filing? And by having all the statutes consolidated under one single chapter, it has now allowed us to start developing a single petition. Another reason for this legislation is the fact that court we know can be very traumatic when you're already experiencing trauma for multiple reasons because of all the barriers in society. Maybe there's a lack of community support, and now you're being expected to navigate a legal system that can be really confusing, that can be sometimes very hostile, and not treat survivors with dignity. So this was an opportunity to really make sure that the statutes were updated to really center the survivor experience. And this has been a much longer process, but legislatively, the focus has been on the 2021 session, which was the original introduction of the legislation that allowed to combine the different protection order statutes into one chapter. It allowed us to incorporate a lot of relevant case law that we had been citing to for a long time. And this was an opportunity to codify that case law. The use of technology, the pandemic, surprisingly allowed us to be more creative in making sure that survivors had access to the courts by being able to appear remotely, by being able to electronically file their petitions, and wanting to make sure those practices stayed in place, and also figure out ways to reduce burdens on litigants. And so often we have respondents and survivor petitioners who are being shuffled between courts and aren't necessarily getting all the information about the process and procedure, and making sure that there was more clarification there and the process is made easier. This legislative session, HB 1901, it's the trailer bill. This was an opportunity to basically include updates and corrections and amendments based on 1320, things that had been identified that needed more time to review. So it allowed us to revise jurisdiction. It standardized the transfer process between courts, what happens when district court sends a case up to Superior Court. Something that I know many of us are super excited about. It adds the definition, it adds coercive control as a definition of domestic violence, sort of recognizing the full spectrum of abuse somebody experienced in an abusive relationship. And then it also clarifies service and hearing issues, and also standardizes other forms of relief and responses to violations. So because I'm talking about coercive control and the excitement, we thought we would start out by identifying some of the definitions that the new legislation is looking at, we wanted to highlight in the new legislation. A lot of the definitions are still the same. So if you have been handling domestic violence protection orders, if you've been handling sexual assault protection orders, anti-harassment, stalking, overall the definitions are still pretty much the same, but there have been updates here and there that I think actually improve the process and hopefully will make it better for petitioners that you are working with. On updated definitions that has included abuse, which is abuse related to VAPOs, vulnerable adult protection orders, updated definition to domestic violence. I'm not going to highlight all of them, but for example, with domestic violence, in the past, there was language about there had to be imminent harm, and that has been removed. So the harm is no longer required to be imminent, but that there has been infliction of fear of physical harm. That does not have to be imminent. That is an update to the domestic violence definition. Intimate partner, this was a definition that also was updated to include also, for example, clarification that if a child is shared biologically, but may have been the result of a sexual assault, that person is not your intimate partner. In the past, there was no way to classify that kind of relationship. And often it was seen as an intimate partner relationship. Family household members have also been updated to include a parent's intimate partner. So in the past, for example, if, parents' significant other, meaning like mom's boyfriend or dad's girlfriend, is sexually assaulting or abusing the child, but they don't live in the same house and they have the dating relationship with a parent, but have no other relationship with the child, that sometimes did not meet the definition of domestic violence. So making sure the definition was updated is there as well. Sexual conduct, because of our focus on sexual assault, just wanted to highlight that sexual conduct, hold on, let me find it. I just want to make sure I'm explaining this correctly. The sexual conduct was related to reducing the age, or in the past, the first sexual conduct in the SAPO statute, it was 13 years or younger, but it's now been expanded to age 16 or younger for any sort of sexual conduct against a minor. And then, of course, updates to stalking, unlawful harassment. These are updated definitions. These are terms that already existed in the different protection order statutes, and in developing RCW 7.105 and drafting the new chapter, it was an opportunity to create some updates to these definitions. Some new definitions that are now also a part of the statute is, for example, consent. Consent was never previously defined under the civil statute, civil protection order statute, but now there is a definition based on the concept of affirmative consent, which basically says that consent cannot be consent cannot be freely given when the other party has authority or control or care or custody of a person. So this includes people who are incarcerated, which brings the definition of consent more in line with the federal definition under the Prison Rape Elimination Act. And then consent also is now defined under the new statute as actual words or conduct indicating a freely given agreement to sexual contact. The definition also makes it very clear that consent can be revoked at any time, that it's not just permanently given, and that consent is also cannot be freely given when somebody is intoxicated or maybe based on age. So the definition of consent will hopefully also help add some clarification around when a sexual assault is a conduct that can be protected under the statute. Other new definitions around firearms. So I'm not going to go into everything, but it also includes like ghost guns. What is a full hearing? What is a full protection order, possession, temporary protection order, and coercive control, which again, many of us are very excited about. So this is the really basic introduction to coercive control. It talks about what coercive control is and what it is not. So protective actions taken by a party in good faith to protect their children, for example, is not coercive control. And then the statute actually, I did not list it fully out, but the statute actually then goes through and gives examples of what coercive control can include. It's not an exhaustive list, but it's a pretty good list. And my understanding is it's the most comprehensive definition of coercive control nationally. So quite a few other states are now looking at our definition that's been developed here in Washington. And so some of the examples that includes using technology to threaten, to humiliate, to control, to monitor a litigant, a survivor, carrying and exhibiting firearms, controlling somebody's documents, identity documents, immigration documents, driving recklessly, and making threats to or making public private information related to litigants, a petitioner's sexual orientation, gender identity, medical or mental health information, essentially to humiliate or control them. Engaging in sexual or reproductive coercion. This is something that was not previously identified as a protective, as a basis to get a protection order. Engaging in vexatious or abusive litigation. So these are just some of the examples of conduct that is now defined under coercive control as an example of domestic violence. And we've cited to the part of the statute that includes all the definitions of terms throughout this chapter. Course of control was just added under HB 1901, which has passed, but it has not been codified. So you're not going to see it in 7105 yet. But once it's codified, you'll be able to pull up the long list of the definitions. And until then, you can look up HB 1901, the actual bill itself, to look at the definitions and see if it applies to any of the cases that you're working on. So this is you, Sarah.
Yeah, so jurisdiction and venue. So for jurisdiction, there is now concurrent superior and district court jurisdiction for 4 of the 6 protection orders. Reedy, can you do the next slide? Domestic violence protection orders, sexual assault protection orders, stalking protection orders, and anti-harassment protection orders. Extreme risk protection orders, temporary orders can be issued in, district court can issue only temporary orders. And then for vulnerable adult protection orders, those are handled exclusively in superior court. Just sort of practically how this might look. If the case is going to be transferred from, in some cases, a case will need to be transferred from district court to superior court. Superior court will make the determination as to whether to grant any requests for a continuance. District court will transfer and set a hearing for superior court once the case is transferred. Municipal courts are now excluded, are excluded from the statute, and the reason for that is they don't have a clear constitutional authority to hear protection order cases. So you're dealing just with superior and district courts. And as I mentioned, transfer, there are some situations where a district court will need to transfer a case to superior court. That's mandatory in certain situations and has to be done with written findings. If superior court has exercised or is exercising jurisdiction over another proceeding involving the parties, if the action would have the effect of interfering with respondent's care, control, or custody of their minor child, if it would affect the use or enjoyment of real property for which the respondent has a cognizable claim, or would exclude a party from a shared dwelling, which is something that we often would see ordered in domestic violence protection orders. If the petitioner, the victim, or the respondent is under 18, or if district court is unable to verify whether there are potentially conflicting or related orders, as required by RCW 7105-555. And that is, that talks about JIS, Judicial Information Systems, where the court can go in and see everything a party may have pending or may have matters in the past. And then 7105-1054, that mandates disclosure of other proceedings by the parties to the court, and it also mandates verification of that by the court administrator. During the work on the statute, stakeholder groups sort of exposed that a lot of courts are inadequately trained and prepared to handle these cases, and especially that was the case with district courts. So where possible, we strongly suggest that you consider just filing in superior court from the beginning. And then for venue, there's now uniform venue requirements for all 6 types of petitions. So a petitioner may file in a county where they reside, the county in which the act that gave rise to the petition occurred, where a child or children to be protected by the order primarily reside, where the petitioner may have resided prior to relocating if that relocation was due to the respondent's conduct, or in the court nearest to the petitioner's residence or that former residence if there was relocation. even if that's in a different county. And that could happen sort of just depending on where the petitioner lives within a certain county. There may be a courthouse closer, but located in another county.
Filing in, yeah, filing in. So this was a huge, huge, I think, barrier for many survivors, many of us who are working with survivors over the years, which is where does the survivor, how does a petitioner decide which protection order is the appropriate one for them to file? And we've seen where initially they may have filed a SAPO and then it gets denied because it's not based on the domestic relationship. It should have been a DVPO, or they filed for a stalking protection order, but maybe it should have been a DVPO. So we've seen this happen. And now under the new law, basically, the survivor is when there is a domestic relationship, they should seek a DVPO rather than a sexual assault protection order or stalking or anti-harassment, but are not required to file for a DVPO as long as it meets the definition under one of the other types of abusive conduct. And this basically addresses the ongoing issue that we had been seeing in the field, which is petitioners having their petitions dismissed or denied because they filed the wrong type of court order. So what are some considerations related to filing that we are excited about in this legislation? Most of it's about expanding access and making sure more people are able to access services. One of that is that any youth 15 years or older may file for a petition of any type. The statutes were originally very inconsistent about at what age you could file. Some were 15, some were 16, some were 18. And so this makes it consistent across, except for vulnerable adult protection orders, which do not apply to youth. So with that exception, 15 years or older can petition for themselves for any protection order. Also, a person may file a petition on behalf of another person who may not be a vulnerable adult. So an example would be, for example, if somebody's incarcerated and they themselves may not be able to file a petition, but if they do have somebody else who might be willing to file a petition on their behalf, or somebody who's currently in the hospital because of medical issues, who may not be able to file a petition for themselves. So expanding the ability to have a third party come file for somebody who may not be able to file for themselves. Another expansion related to filing is really making sure that the courts are the ones that communicate with each other. If a petition is filed in a court that may not have jurisdiction over that case, instead of requiring the petitioner to go on a goose chase to try to figure out how do they get the petition or file the petition in the right courthouse. So that's been another expansion related to filing. Filing electronic protection orders, essentially filing for a petition at any time of the day through electronic filing, making sure that petitioners aren't limited to only filing just during business hours, but can actually file at any time. It doesn't mean that the court will issue a temporary order immediately or it will get processed immediately. The statute does clarify it's about the next business day that temporary order may be issued and it may be handled, but at least the filing part can be handled at any time electronically. And also related to filing, it was very inconsistent in jurisdictions about petitioners actually getting copies of the full service packet and getting it emailed to them. So making sure that petitioners consistently get copies of the packet, including their petition and temporary orders, to make sure that the respondent can be served and make sure that they have the protective paperwork that they need. Another thing that it's surprising it's taken so long, but actually needed to be included in this legislation, is that it's actually okay to electronically sign documents, something that makes it a lot more accessible for petitioners, for attorneys, for witnesses to be able to participate and represent in these cases.
So along with coercive control, I think something else that everyone is probably very excited about is the reforms in terms of service, which could often be incredibly problematic and one of the largest barriers for petitioners. So we now have electronic service. Prior to that, all six types of protection orders specifically required personal service of the petition to be attempted. And the only types of alternative service authorized by statute were by mail or publication. There was no provision permitting electronic service. So now, with electronic service being prioritized, delays and the need for more hearings will hopefully be minimized, and the process for petitioners and really all parties, respondents, law enforcement, and the courts should be simplified and modernized. So as I said, electronic service is to be prioritized and affected by law enforcement unless the petitioner elects to do third-party service. Court authorization is not required unless personal service was initially required in the limited circumstances in which it is. In those cases, electronic service can be authorized after the request of the petitioner or for good cause. And you don't need a formal motion from the petitioner. A request is sufficient. In order to provide proof of service, verification can include a read receipt, a response, a sworn statement from the person who effected service, verifying the transmission, and any follow-up communication like email or telephone contact that further verifies the notice, and then just appearance by the respondent at a hearing as well.
I just want to point out the no formal motion is actually such a relief to have that legislation now, because we know for example, service by mail, often you had to make the formal like request and go back to court. And now with the service language, wherever it's been possible, the attempt was to make sure that it would be more automatic than having a petitioner have to file a formal motion.
So I think I had touched on certain circumstances where personal service is required. So service by law enforcement is required in cases involving required surrender of firearms, transfer of custody of a child or children from the respondent to the petitioner, when a respondent is to be vacated from the party's shared residence, or when a respondent is incarcerated. When those situations are resolved, the firearms are surrendered, the respondent is removed, then subsequent filings and pleadings can be served electronically. It's important, a good practice tip, don't use a hybrid service approach. So like when there's an order to surrender and prohibit weapons, so don't electronically serve the petition and temporary order and then delay serving the order to surrender firearms until it can be done in person, because that will result in respondents receiving notice of the temporary order and then continuing to have access to their firearms that they really are prohibited from possessing. And that just increased risk to the petitioner. It also increases risk to law enforcement and first responders who will be serving them. Service of this is another really important reform and one to be celebrated. Service of protection orders must take precedence for law enforcement. And some other sort of guidelines for law enforcement service are that where personal service is required, the first attempt at service must occur within 24 hours of receiving the order from the court whenever practicable, and not more than 5 days after receiving the order. If the transmittal of the order is delayed or service has not been affected for whatever reason, and it's within 5 days of the hearing, law enforcement should keep attempting to serve and recover any firearms if ordered up to the hearing date. And I'm sure all of you experienced, as I did, there are times when law enforcement would say, well, the respondent's required to have notice 5 days before the hearing anyway, so we're not going to keep, what's the point? We're not going to keep trying to serve. So that is addressed. That is addressed for purposes of petitioner and community safety, which is good. Law enforcement has to document all attempts at service on a proof of service form and then submit that to the court in a timely manner. They're also to include additional details on that form. So for example, maybe the respondent's reaction, if the respondent made any threats, if the respondent made any statements regarding the petitioner, maybe regarding firearms or weapons, that additional information is to be included on the proof of service so the court will be aware of it. And then this is not new for protection orders, I think, except for vulnerable adult orders. If service cannot be completed within 10 calendar days, then the officer must notify the petitioner. And the law includes a new provision to, again, explicitly provide that in these circumstances, law enforcement needs to continue to attempt to complete service unless directed otherwise by the court. The court must not require more than 2 attempts at personal service before permitting service by other means, unless, again, the moving party requests additional time to attempt service. And this was this was previously part of the DVPO statute. Just a couple other reforms, again, looking at a law enforcement's role. If the respondent is in the protected person's presence at the time law enforcement makes contact for service, law enforcement should take reasonable steps to separate the parties when possible prior to completing the service or inquiring about or collecting firearms. And when the order requires the respondent to vacate the shared residence, law enforcement must take reasonable steps to ensure a respondent has left the premises and is on notice that return would be a violation of the order. And then if a law enforcement officer is serving a protection order on a respondent and they acknowledge the respondent requires special assistance due to a disability, a brain injury, or impairment, they need to make a reasonable effort to accommodate the needs of that respondent to the extent practicable without compromising safety of the petitioner. Again, this was something from the DVPO statute. Let's see, other than that, I think the only other thing to note is if the respondent has moved from the county that the law enforcement agency is located in, that the court sent the order for service, and personal service is not required, that law enforcement agency may electronically serve the order. They don't need to send the order back to the court or forward the order to the law enforcement agency where the respondent is now residing. If personal service is not required, that agency can handle the electronic service.
In the past, for some of the previous protection order statutes, a lot of the language around service, especially with law enforcement, was discretionary. So that is, I think, one big change where it's taken some of the discretion out and it's made it much more, it's mandating action by law enforcement around service, which hopefully takes the burden off of petitioners.
And so alternative service options still exist, the ones we're familiar with, service by mail and service by publication. After 2 attempts, the court can permit service by other means unless the moving party requests additional time to attempt service. Here again, the court will affirmatively order service by mail without requiring formal motion by the petitioner. And then where service by mail is completed by a third party, the clerk has to forward proof of that service to the law enforcement agency in the county or municipality where the respondent resides. Service by publication is permitted only in cases where all other means of service have been unsuccessful or are not possible because there's just no known physical or electronic address for the respondent. and the court can authorize multiple methods of service as long as they're used only as permitted, and the court can consider use of any address that it determines to be appropriate in order to authorize service that is reasonably probable to provide actual notice. Some other considerations, the court must favor speedy and cost-effective methods of service in order to promote prompt and accessible resolution of the petition. The court shall not dismiss over the objection of a petitioner a petition for a protection order or a motion to renew a protection order based on the inability of law enforcement or the petitioner to serve the respondent, unless the court determines that all available methods of service have been attempted unsuccessfully. And then when service is to be completed by a law enforcement officer, the clerk of the court has to electronically forward a copy of that order, the confidential information form, the petition, any documents for the protection order on or before the next judicial day to the law enforcement agency. And let's see, anything else to be considered here? One other thing, where electronic service was not complete because there was you couldn't obtain verification of notice and service by mail or publication is authorized, you still must send copies by electronic means to any known electronic address. So continue to attempt that electronic service along with the service by mail or publication.
In the past, it was sort of like you try one, you try the other, you try the next thing. And the nice thing about the statute this time is that you can simultaneously be trying to serve in multiple ways, which hopefully allows service to be completed more efficiently. And I think that's one of the benefits of the updates in the new legislation. Related to service and figuring out timing. If there is, similar to the previous protection order statute, it is still 5 days before the hearing that a party needs to be served, a respondent needs to be served before a hearing, unless it's waived by the respondent, and it can be waived by the respondent showing up in court. And so the 5-day rule still applies. If the court does allow for service by mail or publication, now the hearing needs to be set no later than 30 days out. I think in the past it was 21 days. It had to be set 21 days, but that's been expanded to be 30 days. And service is considered completed in a couple of different ways. Of course, personally served, that is what traditionally the courts have always recognized. Now it's also based on the date of transmission of the electronic service, but that also includes that notification about the read receipt, and in the previous slide where we talked about like the different ways that electronic service can be verified. 10 calendar days after mailing a service packet out, or after the third publication, after there's been attempt by service by publication for 3 consecutive weeks. With requesting service, and as an alternative, service by mail can be made. And this is also considered complete on the 3rd calendar day. So essentially the mailbox rule, the 3rd calendar day after mailing. The timeline with service, once service is completed, it hasn't changed significantly, but there are small changes here just to be paying attention to, depending on the type of service that is being applied. I'm trying to think, is there anything else? For minors involved where maybe the respondent is a minor, service is considered, service must be completed on a parent or a guardian at the address where the minor resides, or it could be served at DCYF if the respondent is subject to a dependency court hearing. And then I'm trying to see. So now with service, it's much more clear and consistent about what materials need to be served and must be served. A lot of times what we would see would happen with service is maybe the petition got served, but the temporary order didn't get served, or the temporary order got served, but the witness declarations didn't get served. And now the legislation clarifies what all needs to be served in order for service to be completed. And I think, I'm trying to see my notes if there's anything else. Yeah, I think that's the last part of when service is completed that we just wanted to make sure to share. Just a quick visual break. Usually for any of you who've come to our trainings in the past, we usually put a lot of videos and visual sort of little breaks in, but this presentation is just super text heavy. So we wanted to create a little bit of a visual break. I'm also seeing questions in the chat. Sarah and I are kind of going back and forth, but we won't be able to answer all the questions that come through the chat. Please keep asking those questions because we'll send out a Q&A after this with the PowerPoint and the handout and our cheat sheet that we're putting together related to 7105. So now we've talked about service, we've talked about definitions, we've talked about filing, now the actual hearing itself. So what are some things to be thinking about related to the hearing? The most important thing is starting out with ex parte, because we know that's how that kind of sometimes sets the tone. If an ex parte temporary protection order is denied, the court must still set a full hearing on the petition for the protection order. So some of the protection order statutes allowed this, specified this, others did not. This makes it consistent throughout, regardless of what type of protection being sought. That even if it's denied at ex parte, it still needs to be set for a protection order. And the court can also give the petitioner 14 days to amend their petition if it feels like there isn't enough information to go forward on a hearing. And so the court should ask the petitioner if they would like to actually amend their petition, if they want time to amend the petition. So the court is also not just sitting there with a case that's just open and it's not clear if it's going to move forward or not. So if the petitioner informs the court prior to a scheduled hearing that the respondent has not been served at least 5 judicial days before the hearing, or the parties have informed the court of an agreed continuance date for the hearing, the court shall reissue any temporary protection orders previously issued, cancel the scheduled hearing, and reset the hearing. And so with ex parte hearings, the main thing is to remember that even if it's denied at ex parte, it should still get set for a full hearing, or at a minimum, the petitioner should be given 14 days to be able to amend their petition and come back. The other part of ex parte hearings and the temporary temporary order is now, in order to get ex parte, a temporary order in ex parte, the petitioner needs to allege that serious harm, immediate harm, or irreparable injury could result if a temporary order is not issued immediately. So the language was inconsistent through the different statutes, and so this brings some consistency there as well. And then this is another area that we're super excited about, which is being able to have remote hearings. We know so many of our clients, so many petitioners, they want to be able to get the petition, they want to go forward with the hearing, but even going to court, standing next to their abuser, their rapist, is just so terrifying. So there is now an option to be able to request a remote hearing, hearing by phone or hearing virtually. So the courts will still have discretion about including allowing hearing by phone, telephone, or other electronic means. But parties, so this is not just petitioner, it could also be respondent as well, must let the court know no less than 3 judicial days before the hearing if they want to appear remotely. And so by default, the court should be granting this opportunity to appear remotely unless the court finds good cause as to why in-person attendance is needed. And this again is also just a reminder, and this is something that's said throughout the statute, that protection order hearings are special proceedings. It's one reason why the remote hearings are something that legislatively it makes sense to allow. Some other aspects of remote and in-person hearing that the legislation clarifies is that advocates and support persons are allowed to accompany the petitioner, and that includes appearing remotely with them if the petitioner wants to appear remotely. Not all of the different statutes actually specified advocates before. And so now with 7105, there's consistency around making sure that a petitioner has access to an advocate or a support person if they want them to be in that hearing. There's also clear provisions around interpretation and making sure petitioners and litigants, respondents have access to interpreters. Another part of, well, some of this we'll also talk about later, but I'm looking at my notes again. Yeah, this we'll talk about in a couple of other slides, but one thing the statute does say now, where the option is available for safety purposes, if a petitioner is going to be in court for an in-person hearing, the court should arrange for the petitioner to leave the court premises first and have court security escort petitioners to their vehicles and transportation, because we also know just how sometimes dangerous and heated these hearings can get, and how sometimes our client's safety is at risk right after a hearing.
Okay, so there are identity and privacy issues sort of special to remote hearings, having these remote hearings, even though it's certainly convenient and something we're happy about. So the court needs to require assurance of the identity of the persons appearing for the hearings. Parties cannot be charged any fees for remote appearances. In terms of access, technology that accommodates ASL and other languages must be used. The court cannot post or should not post or stream proceedings or recordings of protection order hearings online beyond to those authorized to participate, except in limited circumstances. And in terms of what those limited circumstances might be, it may be if all the parties sign a waiver allowing that to happen, or if for some reason the public is not going to have access to that hearing. And that access could be just the ability to physically walk into the courtroom and see the hearing take place. The court, it's very important that the court understand the impact, the harmful impact of posting and streaming protection order proceedings. And that is something that the bench is being made aware of in terms of recommended trauma-informed practices. There's some question as to, there was some pushback, and I think there probably still is some question as to how that impacts public's access to the court proceedings. Holding a hearing remotely and limiting it to the parties and legally authorized participants doesn't provide less public access than if the hearing were held in person where others can observe. It just limits the ability to record, film, and disseminate. So at another training that was done, a judicial officer asked if streaming is the same thing as holding a hearing remotely, and it's not. It's very important to understand that streaming refers to making the hearing open online, or broadcasting the hearing. It's not the same thing, and the public will still have that physical access to the courtrooms. The court needs to take appropriate measures to prevent communication by members of the public and any harassment or intimidation of parties to the case. The public needs to know that recording, and the parties need to know that recording or broadcasting any portion of the hearing is strictly prohibited without prior court approval. Phone numbers, emails, and other contact information for parties and witnesses need to be, the privacy needs to be protected. And there need to be warnings in the materials to the parties and witnesses and others appearing remotely to not state their address or phone number during the hearing, and advise that their backgrounds should not reveal their location. And then a party attending a hearing remotely who is unable to participate in the hearing outside the presence of others who reside with them. So if you are at home and an example would be if you're home and it's your hearing and you anticipated not having your children present, but something happened and now your children are present, you may request, and you shall be granted one continuance on that basis. And there can be subsequent requests, but whether it's granted is discretionary at that point. A couple other reforms that are important to know is that before dismissing or granting a petition due to a party not appearing for a remote hearing, or the court not being able to reach a party via telephone or video, the court needs to check for any notifications to the court regarding issues with remote access or technological difficulties. The parties are to be provided before the hearing with a telephone number and an email address so that they can inform the court if they are having those kind of difficulties or they are unable to appear remotely for their hearing. If they have notified the court of this, the court shall not dismiss or grant the petition, but reset the hearing and reissue the current temporary order if one is in place. And if the party was unable to provide that notification regarding issues with remote access, they can seek relief via a motion for reconsideration. And we actually, just briefly, we saw this happen several times, I hate to say, where someone, because of a technological difficulty, or even because the court, someone had transcribed the phone number incorrectly, a petitioner was not contacted for their hearing or wasn't able to participate in their hearing, and their case was dismissed and they had to start again. So this is really important. And then let's see, I want to speed up because I know we're running short on time. The court needs to include directions so that parties can request interpreters and accommodations for any disabilities. Also, once you have notified the court of your need for an interpreter and one has been provided at that first hearing, the burden is on the court to ensure that an interpreter is provided for the remainder of the hearings. You do not need to keep making that request. So I'll go ahead and move on in the interest of time here. A lot or many of the provisions in the new statute come from case law. They're just now being codified, and this is a very important one. So oftentimes in protection order proceedings, there may be, particularly domestic violence and sexual assault protection order proceedings, there may be parallel criminal proceedings involving the same parties and the same conduct. Now there is a codified, process for how that should be handled, though it had previously been clear from case law. So when that happens, the court has to consider on the record 8 specific factors. They come from, they're called the Olympic pipeline factors, and they were first applied to protection order proceedings in a case Smith v. Smith, which was a domestic violence protection order proceeding. So when considering a request to stay, continue, or delay a hearing because of that pending parallel criminal investigation or prosecution of a respondent, first, the court will apply a rebuttable presumption against such delay and give due recognition to the purpose of the law, which is to provide victims quick and effective relief. And then, as I said, they have to, on the record, go through these 8 Olympic pipeline factors. And I won't go through all of them with you, but I would very much recommend you all review the Smith versus Smith case, because in that case, the court actually found, just briefly found that the respondent's Fifth Amendment right was, risk to their Fifth Amendment right was actually pretty diminished, because protection order proceedings are special proceedings, unlike other civil proceedings, and found, in that case, found that there would not be further continuance or stay, that the petitioner was prejudiced by further continuances in the case. So, and we can send that site out with the Q&A after the presentation. And for other continuances, in other circumstances, again, the court is always to consider the rebuttable presumption against delay, and acknowledge that a victim's quick and effective relief is the purpose of the protection order proceeding. If either party requests a continuance, there needs to be proper notice for witnesses if the court finds that live testimony of witnesses is necessary and material, or to afford party a time to seek counsel. Those are all reasons the court may continue the hearing. It's discretionary. The court, when the court continues a hearing, the court will reissue the temporary orders, including orders to surrender and prohibit weapons. If a temporary protection order is reissued, the court shall reset the hearing date not later than 14 days from the reissued date. However, Reedy, correct me if I'm wrong, it can be longer than that if the parties are in agreement. And that's important. If a temporary protection order is reissued and the court permits service by mail or publication, then the hearing will be set not later than 30 days from the date of the order authorizing that service. And then those timeframes can be extended for good cause. As I mentioned a minute ago, I think I mentioned protection orders are special proceedings. So that is especially true and demonstrated in talking about evidence and discovery. So these proceedings are limited in nature. So they can be conducted upon the information provided in the sworn petition, declarations, in the documentation filed for the case. It can also be presented through live testimony of either party if they choose to testify. Live testimony of witnesses other than the parties can be requested by a party, but it won't be permitted unless the court finds that live testimony of witnesses other than parties is necessary and material. Rules of evidence need not apply other than privilege, the Rape Shield Statute, and Evidence Rule 412 and 413. Again, none of this is new. It's just that this had all been established by case law, and now it's codified. Discovery is only permitted if specifically authorized by the court for good cause, shown upon written motion of a party, filed 6 judicial days prior to the hearing and served prior to the hearing. And if there must be an inquiry into the petitioner's capacity to consent if sexual assault involved intoxicants. So whenever capacity of a petitioner is brought up in the petition. So if, if there was any sort of, if the facts include any sort of consumption of alcohol or substances, and there's any question that the petitioner had capacity to consent, that's something that has to be specifically and separately addressed by the court. And there was one other thing. Oh, go ahead, Reedy.
I just want to quickly clarify Evidence Rule 412. So we're talking about sexual history of a petitioner. So that's what 412 is about. And 413 is the new, I shouldn't say new, but the Washington Evidence Rule that also protects immigration status. So I just wanted to just clarify those two.
Yeah, thank you, Reedy. Something else that popped into my mind, but now I'm not sure. I think why this is important is because, again, just coming back to the purpose of these hearings, even though there's a large body of law around it and all these sort of rules and mandates, this really is meant to be something that a petitioner can navigate and handle on their own. And so we're often seeing, as I'm sure all of you were too, sometimes these hearings turning into what seemed like full trials, which was not the legislative intent and was not good, frankly, for either party. So,
with hearing decisions, this is also, again, combining different aspects of the different statutes as to why a court might not cannot be a basis to deny a petition. So one is that either the petitioner or the respondent is a minor. We've seen this often happen where, because maybe the respondent is a minor, the court is very concerned about the respondent's future, that somehow the trauma that the petitioner has been through is just not treated as seriously. So the age of the parties cannot be a reason to not issue a protection order. Again, something that we all know, this is very true in the DVPO context, but actually we've seen this be a basis in stalking, for example, stalking protection orders not to be granted, which is the petitioner deciding not to report to law enforcement, not denying. A court can't deny based on the fact that a no contact order or restraining order exists in some other proceeding, or because the petitioner might be able to get a similar remedy through a different proceeding, which we've seen the family law and parenting plan process often be used against petitioners in the DV process to not allow a DVPO to go forward. The passage of time, we all know this. Case law, again, this is codification of case law, that the passage of time cannot be a basis to deny a petition, and also the fact that a respondent no longer lives close to a petitioner. It seems very common sense for those of us who are working in this field and working with survivors every day, but it seemed that that needed to really be clarified in the new statute as well. Trying to think if there's anything else that I really want to like highlight.
I don't know what our I don't know what our end time was. We just have a few more slides to go, just for everybody.
Yeah. So we had scheduled this from 12 to 1:15 because we knew it was longer. Usually we keep the extra 15 minutes for questions and answers, but we're just going to use all that time to basically go through the rest of these slides. Another part of the hearing decision I do want to highlight, the sexual assault protection order had also some very specific requirements around why the court or clarification about why the court should not deny, or basis that a court can't use to deny. And so that this now also applies statutorily across the board, which is if a respondent was voluntarily intoxicated or a petitioner was voluntarily intoxicated, that can't be used against them to then dismiss a petition. If there was consensual sexual contact initially, if the petitioner engaged in limited consensual sexual contact, that also can't be a basis to deny a petition. And then for stalking protection orders, for example, there was language about the respondent had to, the petitioner had to show intent. And so a lot of that language has been now removed about like the intent. And so making sure that that isn't an additional burden on the petitioner to somehow prove the intent of the respondent. So that's also been a huge, I think, positive in the new legislation. And if the court does decline to issue a protection order, it needs to state in writing the specific reasons that the court is denying the petition. So relief and remedies, I'm actually going to, because I know folks are going to be jumping off soon, I'm going to put in our chat the survey. This is especially if you're getting, you're asking for CLE credits, please make sure to fill the survey out so that we can make sure to get your information to the WSBA. Also, because we are trying to fill a lot of information in a short period of time, this is also a great place if you have questions that you felt like were unaddressed and unanswered. Please feel free to put that in the survey as well so that we can put that in our Q&A when we send out materials. So there's a couple of different ways to look at relief. There's new relief, and then there's also things that are not permitted. So talking about some of the new remedies that are now available through the statute, there's more comprehensive authority to restrain contact. So, and what I mean by that is in the past, for example, in DV cases, it was just the petitioner themselves who could not be contacted. But in some of these cases involving family and household, now that actually expands to the respondent can't contact the petitioner, the protected party, and family and household members of the protected party. Also, distance restrictions used to only be related to the workplace, the residence, and often we were advising petitioners or talking to clients and advocates about making sure to write in petitioner's person in the other box. Now it's just in there in the statute saying that the distance restriction also applies to the petitioner's physical person and their vehicle. The statute also very clearly, by default, suggests a 1,000 foot restriction, distance restriction, unless there's a good cause to find a shorter distance that might apply. This only used in the past apply for DVPOs, but now it applies, I think, across to all the types of protection orders, which is costs can be paid by the respondent. So that includes maybe filing fees, costs related to the hearing, and then attorney's fees that the petitioner may have incurred. Realignment, for example, is a relief that was always available in the DVPO context, but now it's been expanded to the anti-harassment hearings as well, when the abuser is the one that might be filing the anti-harassment petition first, and then the court recognizing the abusive dynamic and wanting to make sure that the appropriate party is protected. Also, something that is now explicitly in the legislation is that for permanent orders, like essentially a lifetime order, making it clear that it needs to be entered so that it expires 99 years from the date of entry. Abusive litigation. This is something so many of us see consistently happen against petitioners, against survivors through the protection order process. And so now the statute explicitly gives the court the authority to place restrictions on an abusive or vexatious litigant as a remedy for a petitioner. Things that aren't permitted. So for example, if there is an agreed agreement to an order, there still needs to be a credible threat finding. Sometimes this was often a compromise respondents would make, often with pro se petitioners, where they'd agree with the DVPO, but then they'd remove the credible threat finding. So essentially, it then ended up having these consequences specifically around firearms. So making sure that agreement doesn't end up leaving a petitioner with a protection order that may not be as enforceable as it could have been with a credible threat finding. Also not delaying or deferring a finding or issuing a protection order because another process may be available, another proceeding may be available, or because of a parenting plan. So protection order should not be denied because of an existing parenting plan. Making sure a protection order is not denied because of the concern around the respondent's future and somehow the petitioner's own trauma and safety and needs are then dismissed. And then requiring the petitioner to engage in services, get mental health evaluations, go through treatment, where then the protection order process is flipped and suddenly the petitioner walks away with all these requirements and burdens and court oversight. So that cannot be something that the court should be engaging in. And again, we don't want the protection order process to be punitive against a petitioner or have any sort of chilling effect where petitioners are then suddenly now going to be burdened with fees and costs just because they weren't able to get a protection order. So requiring a petitioner to pay attorney's fees or other costs for a respondent is not permitted. And some other remedies also, working with law enforcement. This was originally only for DVPOs, but because we are allowing family and household members to not only apply for a DVPO, but have the option of filing for a SAPO or a stalking order or anti-harassment order, making sure law enforcement is made available to assist a petitioner in recovering their possession, requiring respondent to vacate the residence and move all their personal items while law enforcement is present. there's a lot of DV and family law related language in here. And I'm not going to read through all of this since it is actually up here. But I do want to point out the abusive litigation language in there again, because that is something that has in the past never existed before in the protection order process. And now it's much more explicit in making sure that that remedy is available to petitioners. And then also bringing in technology and recognizing that a lot of respondents are taking their abuse online. So also limiting a respondent's ability of limiting and preventing a respondent from distributing, possessing, publishing images, intimate images of the petitioner. So is this you, Sarah?
Yeah, so I'll just, I'm gonna wrap up here real quickly, talking about duration of orders and then effective dates of all these new reforms. So quickly, anti-harassment orders can be issued for less than 1 year or more. Extreme risk protection orders, 1 year or more. And then the rest, domestic violence, sexual assault, stalking, and vulnerable adult, 1 year to permanent. We did retain the provision from the DVPO statute that a respondent can only be prohibited from contact with their minor child for a year unless it is entered in a family law case. But the courts must advise petitioners in that case that if they want to continue protection for a period longer than a year, they can petition for renewal of the protection order, or they can seek relief in the family law case. And if a permanent protection order is issued, the law specifies the expiration date to be 99 years from the issuance date. And that is because law enforcement required a specific end date in order to get the order into its system. And then in terms of effective dates for all of these reforms, so I won't go through all this, it's right there. I do just wanna kind of repeat something that Reedy said, which is some of this is not yet codified. So you'll need to refer back to the bill itself. And some deadlines for the courts in order to implement remote filing, tracking, and notification systems. The deadline to do so for superior courts is January of 2023. The deadline to do so for courts of limited jurisdiction is January of 2026. And this kind of goes back again to how the process of drafting and passing this legislation kind of revealed how limiting the district court process is. So again, just sort of a recommendation to attorneys and advocates to consider filing in superior court.
We've used the term codification. I guess I just wanted to clarify in case folks aren't sure. So both legislation, both bills passed. HB 1320 passed last year, HB 1901 passed this year. It was signed in by the governor in March 2022. When we're talking about codification, we're talking about like when they take the bill and all that language that's in there that passed, and then they're typing it into the statute. So it's in place. It just hasn't been codified because it's going to take a little while to put it online and put it into the statute, which is why we're saying for the 1901 updates to like go back to 1901 and check the bill itself until those updates have been made online under 7105.
Yeah, and that's the case for provisions involving service and hearing procedures. So it is important to make that distinction. Thanks, Reedy.
Yeah, with that, it's a lot of information we did not even cover. We did not even go into depth as much as we could have. And we didn't cover a lot of other aspects of the bill, but we wanted to get the conversation started. In May, our colleagues at Northwest Justice Project, King County Bar Association, and we're doing a series of trainings for legal aid attorneys every Friday morning, 9 to noon. And then May 13th, NJP's Family Law Task Force is also going to be looking at the legislation related to protection orders. So there are going to be continued trainings around this. And so feel free to, if you sign up for our updates. We can let you know what those dates are. And you'll also be probably seeing emails about the upcoming trainings, but the plan is to continue with these trainings throughout the next couple of months to make sure all attorneys, all advocates, and as many survivors as we can update and educate on this, they have access to the new information. So don't hesitate to contact us. I hope this was helpful. I'm sorry there was no Q&A this time, but we're tracking all the questions that you sent, and we'll definitely be sending these materials out. Thank you, everyone.
Yeah, thank you, everyone. Thank you, Reedy.